Good morning, everyone. Welcome to the Supreme Court. This is an appeal by Housing Solutions Limited against the Alexander Devine Children's Cancer Trust. Mr. Hutchings QC and Mr. McCreath appear on behalf of the appellant, and Mr. Jordan QC and Ms. Windsor appear on behalf of Respondent. Before I invite Mr. Hutchings to begin, I should make clear that one of the members of the panel, his wife is a trustee of an organisation called East Anglia Children's Hospices, and they control 3 hospices in Cambridge, Norwich and Ipswich. The Association of Children's Hospices is known as Together for Short Lives, and each is also a member of that. And more generally, there is an organisation called Hospice UK, of which again, each is a member. The member of the panel whose wife is a trustee has made donations to funds for hospices and has attended the opening of a hospice, which has nothing whatever to do with the hospice concerned in this case. But we felt that it was right at the very beginning that we draw that to the attention of the parties, and I have informed Council of that just before we started today's hearing. Now, Mr. Hutchings, are you ready to proceed?
My lord, yes.
Yes, well, do proceed then. Oh, I'm sorry, I should also have said that we should take a 5-minute break at 12 o'clock. Yes, do forgive me, Mr. Hutchings, do continue.
My lords, can I begin by just making an apology for the e-bundles and the duplicated authorities that you have. There should be before you now a supplemental bundle which includes 1 or 2 new authorities, not in the original bundles of authorities, but together with the correctly reported versions of the cases that appeared in the original bundle. Yes. My apologies for that.
Well, thank you very much. Don't be too profuse in your apology. It's quite unusual not to have some sort of introduction such as you've given, so you're by no means alone in that.
Thank you. Also, in addition, just one small point, some additional photographs, just a small point, some additional photographs should be with you as well. I think on Friday they were sent. Some are replacements for some of the photographs in the bundle, and there are some additional ones as well.
Yes, we received those and we found them very interesting. Thank you.
My lord, this appeal concerns Section 84(1) of the Law of Property Act 1925 and the power vested in the upper tribunal to discharge or modify restrictive covenants. And in particular, it relates to the public interest limb of ground AA of Section 84(1). The appeal raises, in essence, the question of whether an applicant's conduct in knowingly breaching a covenant by developing before applying to the upper tribunal should, in itself, deprive an applicant of the right to rely on the public interest limb of Section 84(1) AA. The appellant's case is that it does not, and that the Court of Appeal was wrong to find that at the jurisdictional stage of consideration under Section 84(1)AB, matters of conduct were relevant, and that the upper tribunal had fallen into error in not taking those matters of conduct into account at that stage. My lord, we further say that the upper tribunal reached a decision which it was entitled to reach. No error of law is shown, whether in the way it applied Section 84(1)AB at the threshold stage of the test or in the exercise of the discretion. And my lords, our case is straightforward. We say the Court of Appeal fell into error in 3 ways, reflecting our 3 grounds of appeal. In the first place, it misconstrued Section 84(1) and or it placed on the words of the statute, a statutory gloss which was inappropriate, creating in effect a precondition to the operation of the public interest limb. Secondly, and partly as a result of that misconstruction, the Court of Appeal wrongly interfered with an evaluative judgment made by the upper tribunal, which had found that the jurisdictional threshold was met in circumstances where the Court of Appeal was not entitled to do so. And thirdly, the Court of Appeal interfered with the discretion properly exercised by the upper tribunal in deciding to modify the covenants. For the Court of Appeal to have done so, it would have to have been shown that the Court of Appeal's conclusion was the only one true reasonable one. This is a high hurdle which could not be cleared in this case. My Lords, I propose this morning first to take you to section 84.1 and our construction of it, and then to some passages from the upper tribunal decision, followed by some passages from the Court of Appeal decision, and then to address the three grounds of appeal in the order they appear in the written case. And whilst doing so, I will try to address some of the key arguments in the respondent's written case. If time permits, I may comment on one or two other paragraphs in the respondent's written case. My Lords, before I turn to the section itself, I'm going to assume familiarity with the statements of facts and issues.
Yes, you may assume that. And of course, we've read the cases of both parties, and of course, the decision of the tribunal and the judgment of the Court of Appeal.
My Lord, I'm grateful. In the interest of just of updating this court, I should say that the 13 units at Exchange House, the 9 terraced houses and 4 bungalows, are currently used as temporary accommodation by the local authority, housing homeless people to whom the local authority owe a statutory duty to house. That is a temporary arrangement put in place because of the uncertainties over the future of the housing itself. Were the appeal to be successful, then the current intention is that in accordance with the Section 106 agreement, which you will have seen, preventing use other than as social housing, 4 of the bungalows and 3 of the houses will be sold under a shared ownership scheme, and the remaining 6 houses will be used for affordable rent premises. My Lords, before I take you to section 84, I should point out in our written case, we have included reference to parliamentary material, including extracts from parliamentary debates to explain the background to the Act and the mischief it was intended to meet, both as originally enacted and as amended in 1970. We do so in order simply to identify in each case the mischief that the section is designed to meet and to supply context. And we say that material is admissible. My Lords, I'm not going to take you to sections of Benyon on statutory interpretation, but for your note, they do appear in the supplementary bundle of authorities at tab 15, and it's sections 368 to 369 and 373 of Benyon on which we rely. My Lord, we also make reference to Shepherd and Turner and Lord Justice Carnwath's, as he then was, judgment at paragraph 16 to 17, setting out the background to the introduction of ground AA in 1970. Lord Justice Carnwath then returned again to that theme in Winter and Traditional and Contemporary Contracts, which is also in the bundle of authorities, the supplemental bundle at 14361, and at page 366, paragraph 38, he described the purpose of ground AA as being to provide a proper balance between the public interest in facilitating development and the protection of private contractual rights.
Yes.
My Lords, can I now take you to section 84.1? which appears at the core bundle, core authorities, tab 1, it's page 318.
Yes.
Well, that provides by section 1 that the upper tribunal shall, without prejudice to any concurrent jurisdiction of the court, have power from time to time on the application of any person interested but in any freehold land affected by any restriction arising under covenant or otherwise as to use thereof, to wholly or partially discharge or modify such restriction on being satisfied. And then the 4 grounds on which modification can be obtained, modification or discharge. The first one is the obsolescence ground. The second one with which we're concerned is the some reasonable user ground, that in a case falling within subsection 1A, the continued existence thereof would impede the reasonable use, some reasonable user of the land for public or private purposes, or, as the case may be, would, unless modified, so impede such user. And then B is the agreement ground, and C, the no injury ground. And then additionally, and an order discharging or modifying a restricted covenant under this subsection may direct the applicant to pay to any person entitled to the benefit a restriction under one of consideration under one of 2 heads, a sum to make up for any loss or disadvantage suffered by the person in consequence of the discharge, and a sum to make up for any effect which the restriction had when it was imposed in reducing the consideration received. And then key sections 1A and 1B, subject to 1AA, subsection 1AA above authorizes the discharge or modification of a restriction by reference to its impeding some reasonable user of land in any case in which the upper tribunal is satisfied that the restriction in impeding that user either does not secure to persons entitled to the benefit of it any practical benefits of substantial advantage, value or advantage to them, or is contrary to public interest, and that money will be an adequate compensation for the loss or disadvantage which any such person will suffer from the discharge or modification. And then 1B, in determining whether a case is one falling within subsection 1A above, and in determining whether in any such case or otherwise a restriction ought to be discharged or modified, the upper tribunal shall take into account the development plan and any declared or ascertainable pattern for the grant or refusal of planning permission in the relevant areas, as well as the period at which and context in which the restriction was created or imposed, and any other material circumstances. My lords, subsection 2 is concerned with the court's powers to make declarations. Subsection 3 provides that the upper tribunal shall, before making any order under this section, direct inquiries, such inquiries, if any, to be made of any government department, local authority, etc., by way of advertisement, to be given to such of the persons who appear to be entitled to the benefit of the restriction intended to be discharged, modified, or dealt with, as having regard to any inquiries, notices, or other proceedings previously made, given, or taken, the upper tribunal may think fit. My lords, and then 3A is the provision which applies in the tribunal, allowing the tribunal to make decisions as to whether or not objectors should be permitted to object to any application if the applicant doesn't accept that such person should be entitled to object. Subparagraph 5 shows that the operation of section 84, both under limbs 1 and 2, operates in rem and not simply in personam. And subsection 9, which we place some reliance on, that states that where any proceedings by action or otherwise are taken to enforce a restrictive covenant, any person against whom the proceedings are taken may, in such proceedings, apply to the court for an order giving leave to apply to the upper tribunal under this section and staying the proceedings in the meantime. My lords, as I've indicated, we place some emphasis on that. It's of note that in Shepherd and Turner, for example, it would appear that that jurisdiction was used, and in two other cases which are referred to in the written cases, SJC Construction and Re Fisher and Jimson were similarly cases in which the applicant was subject to legal proceedings in court and took the opportunity to apply to seek to modify or discharge the covenant.
Yeah.
Well, Lords, coming back then to section 84(1)(a), we'd say that the wording is clear in identifying what the tribunal are being asked to decide at this stage, at the threshold stage. It authorises the discharge or modification of a restriction by reference to that restriction impeding some reasonable user. So at the jurisdiction stage, in determining whether the threshold is met, the question, having decided that the proposed user, or in our case, the actual user, is a reasonable one, the question is whether the upper tribunal is satisfied that the restriction in impeding that reasonable user is contrary to the public interest. It's a narrower question at this stage. The question is not whether it's in the public interest for the restrictive covenant to remain, but whether the covenant in impeding the intended user is contrary to the public interest. And if so, then the tribunal moved to the next question, the question of whether or not compensation will adequately compensate those affected. My Lords, 1B shows clearly the two stages identified in the tribunal's deliberation. In determining whether a case is one falling within subsection 1A, and in determining whether, in such case or otherwise, a restriction ought to be discharged or modified, it shall take into account the following things. So,
those appear to be two disjunctive functions, don't they? First of all, that in determining whether the case falls within section 1A, the tribunal shall take into account the development plan and declare ascertainable pattern and so on. So that seems to go to jurisdiction, doesn't it?
My Lord, it does, but my reading of the section would be that it also must go to discretion as well, because of the words "and in determining whether."
Oh, yes, quite.
Yeah,
I mean, that's why I said there were two disjunctive.
I'm sorry, I misunderstood.
No, not at all.
No, absolutely, my Lord. All of the matters potentially go to the question of jurisdiction, in the sense that they may be relevant to the jurisdictional question. All also go to the discretionary stage, insofar as they might be relevant. And my Lords, of course, the reality in practice is that if one has a planning permission, which is not interestingly identified in 1B as one of the documents or one of the matters that should be taken into account, the actual planning permission. But if one has an actual planning permission, the reality is that very often questions regarding the development plan and patterns for the grant or refusal planning permissions play a much less significant role at both the jurisdictional stage and at the discretionary stage.
Well, I suppose you would argue, would you, that the consideration of the factors outlined in 1B might well be quite different depending on whether one brings them to bear on the question of jurisdiction or whether they are being considered in relation to the exercise of discretion.
Yeah, my lord, that's right. And for example, I mean, the obvious example of that is other material circumstances. In other words, material circumstances relevant to the jurisdictional threshold might be other planning matters which are not referred to specifically in subsection 1B, planning policies or otherwise, which would play, one would have thought, very little role once the discretionary stage of the test is being considered.
Yes.
And my lord, on that question, to be a material circumstance at the jurisdictional stage under section 84(1)(ab), the public interest limb, we say, of course, that the fact or matter has to be material to whether the restriction is impeding some reasonable user, such as to be contrary to the to the public interest. We place reliance on the word material. It's material to the question of whether or not the restriction is impeding that reasonable user to consider matters relating to planning, but it is not material to the jurisdictional question as to whether or not the conduct of the applicant is to be criticised. So, my lord, if the jurisdictional threshold is met, then one moves to the discretion stage, and as my lord says, conduct, as we accept, and as the tribunal found, conduct is material as to whether the discretion ought to be exercised. It's not material to the question whether, in impeding the reasonable user, the covenant operates contrary to the public interest. And we say that natural, logical, and consistent reading is the reading that the upper tribunal adopted implicitly in its decision. But the Court of Appeal took what we say is a wrong turn by misconstruing that section. In particular, in ignoring that the question at the jurisdictional stage is whether, in determining whether a case is one falling within subsection 1A, in other words, in determining whether the restriction impedes some reasonable user of the land, such as to be contrary to the public interest, the upper tribunal shall take into account, etc. But that's, as I say, a narrower point, a narrower question than the question that we say the Court of Appeal appears to have assumed was the appropriate question to be asked at the jurisdictional stage. My lords, can I then take you to the upper tribunal decision? I'm conscious that my lords have obviously read it and no doubt digested it, but there are, I'm afraid, a few paragraphs that I do just want to emphasize against the background that we say that this was really an unimpeachable decision of the upper tribunal. We have relied in our written case on the fact that a benevolent reading is to be given to these decisions of tribunals by reference to the well-known Sudan case and some of the other cases which I don't, I think, intend to take you to. But this is a decision which doesn't even require, we say, a benevolent reading, because the approach that the tribunal took, whether one agrees with the decision, the outcome or not, the approach that the tribunal took was, as we say, unimpeachable. Lords, can I start with paragraph?
Could I just interrupt you and ask for a second? This question. Lord Justice Sales said it was a relevant factor to the question of jurisdiction whether Millgate could have devised a scheme for the development of the site which concentrated the housing unit on the unencumbered land, and that would have satisfied the council and would also have respected the trust's rights under the restrictive covenant. Now, if that is right, and that would have been taken into account had the application been made in a timely manner, why is it not relevant to the public interest?
Well, my lord, it's because the question is a narrower one, we say. The question is whether the restriction is in impeding the user that is required or exists. If that is affected by the covenant, then it is operating contrary to the public interest.
Well, sorry, may I just interrupt you? May I just interrupt you once more? Just put yourself into the position where the application had been made in a timely manner.
Yes.
And the question would have been whether or not the restriction is contrary to the public interest. Well, now, if it would have been possible for the development to go ahead, respecting the trust's rights under the restrictive covenant, why would it have been in the public interest, or at least why is it not relevant to the public interest for the development to go ahead as it did?
But my lord, because that is not the position that the tribunal were dealing with. The tribunal was met with a situation which where the houses had been built on the burdened land, and so it wasn't. It's not a question at this stage. At the jurisdictional stage, in my submission, to ask what could have or might have happened had the developer behaved differently. It's a narrower question, and of course, my lord, that is a consideration that may bear on the discretionary stage, undoubtedly, but it doesn't. It's not supported by the narrow reading that we say is appropriate for the words of 1A. My lords, can I take you to paragraph 50 first of all? Of the upper tribunal's decision, and this appears at tab 7 in the core bundle at page 165. My lords, in these paragraphs, the upper tribunal acknowledged or found rather that Millgate had been aware of the covenants, and in 51 we have little doubt that a competent firm of solicitors would have no difficulty in identifying at least Mr. Smith and through him the trustees as beneficiaries, and then toward the end of that paragraph we infer that Millgate either took no steps to find out who the beneficiaries of the covenant were or knew the identity of some of or all of them and chose not to raise the issue of the covenants before beginning to build in breach of them. And we make the point there that there is no suggestion being made there in the findings that the tribunal made that the action was taken to force the hand of the tribunal. My Lord, then 53 and 54, reference is made to the 1.64 million payment that was secured, that was arranged by means of a deed of variation to the Section 106 agreement, which would allow Millgate to dispose of the remainder of the housing on its Woolly Hall development rather than comply with the original Section 106, which was for the property to be sold to a social housing provider within a certain period of time. 54, the current position is therefore that the transfer by Millgate of the 13 units cannot proceed, nor can Millgate's remaining properties at Woolly Hall be sold unless either the covenants are modified to permit the units to be occupied, or Millgate pays more than 1.6 million to the local authority. And then, my Lord's, paragraph 63, the point that my Lord Kitchen was making, had it chosen to lay out the exchange site differently, it's likely Millgate could have provided all 23 units entirely on the unburdened land. And then if we can move on to page 173, forgive me, 173. The tribunal in paragraphs 95 and 96 dismiss the application under the first limb of ground AA, being entirely satisfied the contribution the covenants would, but for the breach, have made to the privacy of the within the grounds of the hospice was a real and substantial advantage. And then, my Lords, the tribunal address on page 174, paragraphs 97 onwards, the public interest test. And they refer to a submission made by Mr. Driscoll QC, citing Ruton Park and Lawrence and Fen Tigers. And in 99, they point out that the decision in Lawrence didn't concern restrictive covenants, but that Lord Sumption in his speech had considered how public and private law in the domain of land use ought to be reconciled where they occupy the same space. And they quote from his judgment. And then at the end of that paragraph, there are obvious parallels between the approach which the court should take to the remedies in case of nuisance sanctioned by planning permission, and the approach which the tribunal should take to the public interest limb of section 84(1) AA. Both involve balancing the public interest in efficient use of land and private rights over the same land. And my Lords, we say that's entirely correct and unobjectionable. Over the page, they again, at paragraph 100, page 175, they cite from Lord Sumption's judgment and his suggestion that in a future case, it may be that damages should ordinarily be an adequate remedy in relation to nuisance rather than an injunction. And then at 101, we agree with Mr. Driscoll that the existence of planning permission for the use of the application land for housing is a material consideration under AA. It's generally taken to be conclusive that the proposed user is a reasonable one, but it's also of significance in cases where it's suggested that by impeding a proposed user, a covenant operates contrary to the public interest. And Lord, again, we say that's entirely unobjectionable. It obviously is a material consideration under ground A because it proves, first of all, conclusively, effectively the reasonable user, but it is also of significance when one is considering the public interest limb, and that's implicit from the the words of subsection 1b. As I say, though not citing the planning permission itself or relevant planning permissions, it nevertheless makes clear that the planning permission is of significance. And my lord, that's entirely conventional. It follows the approach that's taken in one of the cases that is cited, was cited both in the upper tribunal and before the Court of Appeal, the SJC construction case, where the tribunal again said that for the purposes of the public interest limb jurisdictional threshold test, the planning permission was an important consideration. And then 102, the fact that planning permission has been granted does not mean that private rights can necessarily be overridden, but it does reflect an objective assessment of appropriate land use, which fully takes into account the public interest. And then reference made to section 84(1)(b) and what it specifically provides must be taken into account. And my lord, it's important to remember at this point, the upper tribunal are considering the question whether the restriction in impeding that reasonable use is contrary to the public interest. And the point being made about fully taking into account the public interest means in effect fully taking into account the public interest in the use of the land. So it is clearly a relevant consideration for the purposes of the jurisdictional test. My lords, in 103, the tribunal set out the passage from Shepherd and Turner, which I made reference to in my opening. And in 104, the fact that the housing in this case is social housing intended for occupation by tenants who are likely to have been waiting for such accommodation for a very, very long time is also a highly material consideration. The local planning authority.
Could I just take you back to paragraph 102 again, please, where the tribunal says that the fact that planning permission has been granted does not mean that private rights can necessarily be overridden, but it does reflect an objective assessment of appropriate land use, which fully takes into account the public interest. Now, would you accept that the public interest comprehends the desirability that restrictive covenants are respected and that they're not to be breached save for good reason?
Absolutely, and it's a point that the upper tribunal itself makes when
planning permission is being considered, does the question of the existence or breach of restrictive covenants come into play at all?
My lords, it doesn't. It doesn't.
But by definition, therefore, the objective assessment of appropriate land use cannot be said to fully take into account the public interest, because it omits that dimension, doesn't it?
Well, my lord, it omits it in the structure of the section at the stage at which one is considering whether the jurisdictional threshold is met. But of course, it doesn't omit it at the point where the discretionary stage is reached.
Right. Well, that might pretend that. Yes, Lord Burrows.
Just a couple of minor points before we get any further. One is, you've referred to the SJC construction case. I may be mistaken, but I could not find in the authorities that you sent the upper tribunal decision in that case, as opposed to the Court of Appeal decision. I'm not asking you to look at it now, but if that isn't there, perhaps we could be supplied with it.
My lord, it is there, and okay. I'm going to take you to it.
The upper tribunal.
The upper tribunal, yes.
Okay.
In fact, I'm not proposing to take you to the Court of Appeal decision. I'm proposing to take you only to the.
Okay. The second point is, in looking at 84(1)(b), the approach that you would take is that planning permission is obviously of central importance. I just wonder, does it therefore follow that it's a bit odd that 1B didn't directly mention that?
My lord, it is slightly odd, I agree. It is, but I think conventionally, the way that the section is interpreted, planning permission is clearly taken to be an important consideration for the purpose of the public interest limb. And of course, my lord, in order to get to that stage, really, one has to prove a reasonable user. That's the first point, really, the first stage of the test in rebus, as it were. Is the proposed user of the land reasonable? And of course, that is invariably answered by the question of whether or not a planning permission has been granted. And there are various tribunal cases which say that bringing an application under AA without having planning permission is a pretty risky thing to do, because you have to try and find some other way of proving that your user is reasonable. So it may have been that, again, although the AA itself doesn't mention planning permission, but it may have been assumed, as it has been, I think, by the tribunal, that in order to show a reasonable user, you nearly always have to have a planning permission.
Thank you.
My lords, at 104, the local planning authority clearly considered the provision of affordable housing was an important part of the balancing of the interests. The houses which have been built are attractive, well built, and are currently standing empty because of the restriction imposed by the covenants. And my lord, I just emphasise in that paragraph that I believe that paragraph does show that the tribunal were not taking the mere fact of planning permission as determinative of the public interest test, because it's clear that they refer to the fact that the planning permission gave permission for social housing was also a highly material consideration. So they're taking into account relevant factors, not simply the fact of planning permission. And then in 105, the tribunal recalled that the objector's case on this issue was understandably rather muted. Mr. Smith acknowledged that it was unlikely the houses would be pulled down. Mrs. Devine was more positive, did not want to see them left empty. And then a key paragraph, it is no answer to the current wasteful state of affairs to say, as Ms. Windsor does, that Millgate could have built the allocation of affordable housing on other land, or that it could now buy its way out of the problem by making a payment towards the provision of social housing elsewhere. Whether these would have been sufficient answers to Millgate's case on public interest if we had been dealing with an appropriate application before any housing had been built on the site is not a question which arises. The question for the tribunal is whether, in impeding the occupation of the houses which now stand on the application land and which are otherwise immediately available to meet a pressing social need, the covenants operate in a way which is contrary to the public interest. And so, my lord, clearly the tribunal recognise that they have been presented with a fait accompli, and that their answer to the question of whether or not the public interest jurisdictional threshold would have been met might have been different had the application been made before any building occurred. But that, of course, was not the situation with which the tribunal was in fact met with. In reaching that conclusion, we're mindful of the tribunal's early jurisprudence, and they make reference to the Reed Collins case, that for an application to succeed on the grounds of public interest, it must be shown the interest is so important and immediate as to justify the serious interference with private rights and the sanctity of contract. Whether that restrictive gloss remains the correct approach may require reconsideration in light of Lord Justice Carnwath's explanation of the policy underlying ground AA and Lord Sumption's observations, on the reconciliation of public and private rights in Lawrence, but it is not necessary to pursue that thought further at this time. We are satisfied that the public interest in play in this case is sufficiently important and immediate to justify the exercise of the tribunal's power under section 84AA to override the objector's private rights. So, my lords, I submit it's clear from that paragraph that the upper tribunal were not suggesting that Lawrence and Fen Tigers had laid down any the judgment of Lord Sumption had laid down any principle that was relevant to be applied for the purposes of determining the question of discretion. But as far as Reed Collins is concerned, of which some criticism was made of in the Court of Appeal of what the Court of Appeal described as really an indication that the upper tribunal was moving away from that jurisprudence. Far from it. The words sufficiently important and immediate, which were the words used in Reed Collins, were found to be satisfied. So the upper tribunal applied the conventional test, whilst admittedly indicating that that test might require reconsideration at some time. They nevertheless adopt an entirely conventional approach. And in paragraph 112, in paragraph 104, my lords, paragraph 112, we're therefore satisfied we have power to, we have power under section 84(1)A to modify the restrictions as requested by Millgate. The next question is whether we should exercise the discretion. And then my lords, discretion, we do not...
Lord Hamblin has a question.
My lord, I'm sorry.
Yeah, Pitachi, so what is your submission on the Reed Collins test? You have one.
My lord, I say this, that it does in fact impose an unnecessary gloss on the words of the statute. But having said that, that is not an issue with which this court needs to be concerned with, because...
Well, I just wonder about that. Without being unduly pernickety, if you read paragraph 107, the Collins test is expressed in fairly forthright terms that the interest is so important and immediate as to justify the serious interference, whereas the tribunal says in the final sentence of the paragraph, we're satisfied that the public interest is sufficiently important and immediate. It may be that there's no justification for distinguishing between those two, but I just wonder whether Mr. Frank QC in Collins was expressing it at a somewhat higher level than the tribunal accepted.
Well, my lord, I'd say two things to that. It seems, in my submission, highly unlikely, having stated correctly the, if it's right to call it, ratio of Reed Collins. Nevertheless, in two sentences later, perhaps the word sufficiently must be taken, surely, to be to relate back to the test as set out in Reed Collins. I mean, it's clear that in my submission, reading that paragraph, and perhaps at this point, modifying a submission I made earlier, if necessary, I say a benevolent reading of that paragraph, surely suggests that the tribunal had in mind the Reed Collins test and applied it. because they make clear it is not necessary to pursue that thought further at this time. In other words, we are not considering whether or not Reed Collins is the right test. We are applying the test.
Yes, well, as you say, we could be dancing in the head of this particular opinion for quite a while.
But
anyway,
yes,
we have your submission.
Indeed. Then at paragraph 114, my lords, at page 177, we do not agree that there is as little in the discretion as Mr. Driscoll suggested. We refute any suggestion that a landowner who is in deliberate breach of trust, but who can show one of the statutory grounds, can confidently assume that the tribunal's discretion will be exercised in favour of modification or discharge. We do so for two reasons. The first, by reference to a decision of the tribunal in George Wimpey, that making it clear that the tribunal is not inclined to reward parties who deliberately flout their legal obligations. And then the second related reason is that too great a readiness on the part of the tribunal to exercise its powers under Section 84 in cases where development has already taken place in breach of covenant would be liable to undermine the protection which restrictive covenants afford. If it was thought to be easier to secure a modification in favour of a completed development than for one which was not yet commenced, the contract maker would have a real incentive to press on in face of strong objections. Any developer who thinks in that way should think again or risk the rude awakening threatened by Mr. Justice Brightman in Ruton Park. So, my lords, the tribunal were acutely conscious of making it clear that they were not giving any truck to the idea that one could breach one's covenant and be in a more advantageous position, but they were making a decision on the facts of this particular case. And they make that clear in 116. Nevertheless, the discretion conferred on the tribunal is to be exercised judicially and not with a view simply to punishing a covenant breaker. And in 117, they quote from the SJC construction case, where the President accepted that the applicant, this is a public interest case, acted in good faith and without intention to force the hand of the beneficiary of the covenant in question. The same cannot be said in this case as Millgate's stated knowledge and its intent are at best unproven. In Winter, the applicant had been unaware of the objector's right to enforce. There's no evidence of that. Ms. Windsor emphasised that unlike the applicants in Green Masjid, Millgate had acted with professional advice and suggested its behaviour was so egregious and unconscionable that relief should be refused. We have taken into account all of the matters of conduct which she relied on. And then they make reference to the open offer that was made after the conclusion of evidence after the conclusion of the hearing of £150,000 to the trust, which influenced them.
Yes, Lord Burrows.
My lord, I'm sorry.
Can I just take you back, please, to paragraph 115? Because what the tribunal was saying was any developer who thinks that they can act, if you like, in an egregious way, go ahead without going through the Section 84 proceedings first, I'd better think again. But the actual decision would indicate that that was pure lip service, wasn't it? That the upper tribunal, they're using those words, but the effect of what they've done is precisely to allow that.
Well, my lord, the effect of what they've done is to find that in the public interest, the need for this housing to be brought into immediate use overrides every other consideration. And that they were acutely conscious that Millgate, in effect, gained an advantage. But that, of course, is not what the public interest limb provides. And my lord, they also made clear that the answer might have been different on the question of discretion if they had only found for Millgate on the limited benefit limb, the no benefit of substantial value or advantage, in which case the decision might have been different given the behaviour of the applicant. But of course, in this case, the question is one of public interest. And because of the fact that there are third-party interests with which the tribunal is in effect concerned, in those circumstances, what the tribunal found was that those interests, despite the behaviour of Millgate, overrode any considerations which concerned the fact that the applicant was indirectly benefiting from the breach of covenant.
But in order to get to the discretionary stage, one has already had to overcome the jurisdictional gateway of it being contrary to the public interest. So the point you're making, would it not then follow that in every case where you've gone from the jurisdictional gateway of the public interest to the discretion, where the developer has cynically operated, you just ignore that? You put it to one side because the public interest overweighs it.
Well, my lord, I don't think that's the rationale of the decision. In this case, faced with what the tribunal was faced with, it found as a balanced decision, exercising its discretion as it is entitled to, as Parliament has entrusted it with, the specialist function of making decisions, often finely balanced decisions, no doubt, as no doubt this one was. The tribunal decided that those factors, the immediate availability of the housing, overrode the discretionary test. But it doesn't, my lord, it doesn't, as the tribunal were clear to point out, it doesn't set any precedent, and it doesn't mean that in any case where the public interest is engaged, you can then ignore the behaviour of the applicant at the discretion stage. And of course, my lord, they didn't ignore the behaviour of the applicant. They said they had taken it fully into account, but as a matter of discretion on this particular occasion, the public need was, the public interest being so great was satisfied and trumped all other factors. And indeed, the point comes out in paragraph 120 that I've just been making to my Lord Burrows. Had we been persuaded of Millgate's case for modification only under the first limb of ground A, we would have found the exercise of our discretion much more difficult. But the ground on which we are satisfied is the alternative public interest limb. Our decision will have an effect not only on the parties, but also on 13 families or individuals who are waiting to be housed in these properties, if and as soon as the restrictions are modified. We consider that the public interest outweighs all other factors in this case. It will indeed be an unconscionable waste of resources for those houses to continue to remain empty. And so that's the point, that ultimately, as a matter of discretion, having taken accountable factors, the tribunal decide that the public interest in this case outweighs all other factors. My lords, can I take you now to the Court of Appeal?
If you're moving on to a different topic, shall we take the break now, slightly before 12, and we'll sit again at 12:05?
My lord, yes.
Thank you very much indeed. Thank you. Now, Mr. Hutchings, I think you were going to take us to the Court of Appeal judgment.
My lord, I was. Just before I do so, can I just also, in response to the point that my Lord Burrows made, one is always dealing here with competing public interests. That's really the point, that one can't say how those competing public interests will play out in a decision that the tribunal makes. It's always going to be a matter of fact as to whether or not one particular competing interest overrides another. My Lord, moving on to the Court of Appeal's judgment. This is at well, I'm going to take it in the supplementary bundle. It was also in the core bundle, but not in its reported form in the weeklies. It's in the supplemental bundle at tab 1, page 3. If my lords are working from the core bundle, the unreported version, it's at tab 4, page 127. My lords, at page 17, paragraph 47, the Court of Appeal set out the power under section 84 1 AA, and make reference in the final 7 or 8 lines to the Collins case, pointing out that, quoting from the case as we've seen, and indicating that that remains the proper approach. And then, rather than expressing doubt about this guidance, at paragraph 107 of its decision, the upper tribunal ought to have followed it. And my lord, I won't repeat my point that we say that is exactly what the upper tribunal did. And then at 49, on a fair and proper reading of the decision, the upper tribunal acceded to Mr. Driscoll's submission that Lord Sumption's guidance regarding the tort of nuisance should be applied by analogy. And my lord, I won't again repeat the point that we say, well, that's simply not a fair and proper reading of the upper tribunal's decision. And over 51, over the page on 51, page 18, the Court of Appeal again indicate that in between C and D, Lord Sumption's suggested approach in that case does not constitute appropriate guidance in the present case. But again, my lords, the tribunal were not treating it as appropriate guidance. All the tribunal was saying was that planning permission was of significance, of real importance, when the public interest ground jurisdictional stage is in play. And then the Court of Appeal said at 52 that the subsection 1B was applied incorrectly. Then towards the end of 53, in my, again, repeated the reference to Lord Sumption's guidance. In my view, to apply Lord Sumption's guidance in the context of deciding whether restrictive covenants should be discharged or overridden pursuant to section 84, fails to give proper weight to the nature of the private rights in issue in this context. And then, my lords, if I can go to 57, which is on page 20. In my judgment, this means that at the stage of application of the contrary to the public interest test, the upper tribunal should have regard to whether the applicant has made fair use of opportunities available to it to try to negotiate a waiver of a restrictive covenant, or if necessary, to test the public interest arguments in an application made under section 84 in advance of acting in breach of covenant. And we say that that, of course, is a judicial gloss on the words, but also a misreading of the words of the section. And that's confirmed towards the end of that paragraph, the last 4 lines beginning between C and D. The contrary to the public interest test has an important dimension which is concerned with such procedural matters and the process followed by the applicant before making its application under section 84. And then 59, as I have said, enforcement of contractual and property rights is generally in the public interest. So it is irrelevant when in assessing under section 84(1)(b) whether the restriction in impeding some reasonable user of land is contrary to the public interest, to see whether the applicant has behaved appropriately in seeking to respect and give due weight to such rights in the course of its dealings with the holder of such rights. So the question of public interest has been tested in an appropriate way. And we say that doesn't follow from the words of the section, not at the jurisdictional stage. Asking questions about the behaviour of the applicant wouldn't answer the objective question that section 1A asks, which is whether the restriction in impeding the reasonable user is contrary to the public interest. And then at the end of 59, last 5 lines just before H, similarly, if an application under 84 is made in advance of any conduct by the developer, that will allow the public interest to be tested in the context of due weight being given to upholding the public interest as regards respect for property and contract rights, rather than in the context where the developer has unilaterally and unlawfully violated those rights. And in relation to that, we say that there's no suggestion in the statutory language that a different test applies depending on the stage at which the application is made. And we point, as my Lords knows, to section 84(9), which shows that the Parliament deliberately contemplated that applications might be made after a breach had occurred. And there is no indication from the language of the statute that section 84(1)(a)(b), the public interest limb, is somehow carved out of that right or power under section 84(9) to seek a stay of legal proceedings when one is acting in breach of covenant. My Lord, at 64, the Court of Appeal say, however, it remains the case that in general terms, it's in the public interest that contracts should be honoured and not breached, and that property rights should be upheld and protected. A property developer which knows of a restricted covenant which impedes its development of land has a fair opportunity before building either to negotiate a release of the covenant or to make an application under section 84. That is how the developer ought to proceed. It's contrary to the public interest in ensuring the proper respect is given to contractual property rights for a property developer to proceed without any good excuse to build in violation of such rights as contained in an enforceable restrictive covenant. And my Lords, these examples we submit confirm that a different question is being asked by the Court of Appeal than that posed by the statute. And furthermore, two key further hurdles are being ignored at that point by the Court of Appeal. First of all, that the tribunal has also to be satisfied for the jurisdictional threshold to be met that monetary compensation is going to be adequate to make up for the breach. And secondly, that as a matter of discretion, it may or may not be appropriate to modify. In this case, it was, but that's the stage where of the test where questions as to the procedures that the applicant has followed come into play.
Mr. Hutchins, is there any reason why this consideration should not be taken into account at more than one stage?
Well, we say there is, which is that the statutory language doesn't allow for that to occur. Again, it's the narrow nature of the test at the jurisdictional stage that answers my Lord's point. And of course, to make it clear, of course, because it doesn't apply at the jurisdictional stage, doesn't mean that full weight can't be given to it at the discretion stage. It's an incoherent, we would say, reading of the statute to say that you take into account conduct as a material circumstance in relation to the jurisdictional stage under the public interest limb test, and then take it into account again at the discretionary stage. At the discretionary stage, my lord, yes.
Yes, thank you.
And at 66, in my view, it's appropriate to bring into account the right space and procedural dimension of the public interest in the interpretation of section 841 AB. And then over the page at 68, in addition, under these grounds, I consider in this part of its decision, the Upper Tribunal has in two respects failed to apply section 841B correctly when arriving at its conclusion. The first respect again relates to the improper weight which the Tribunal gave at 102 to the grant of planning permission. The Upper Tribunal treated section 841B as supportive of its view, but it is not. And then there's reference to the fact that land was in the Greenbelt. The Upper Tribunal did not identify any declared or ascertainable pattern for the grant or refusal of planning permissions, let alone ones which supported Millgate's arguments. But my lords, these were peculiarly matters for the Tribunal to consider and take into account. I mean, the fact that land was in Greenbelt, of course, is supportive of the public interest argument, in that despite the fact that national planning policy restricts development, nevertheless special circumstances were shown, and part of those special circumstances were the fact that the development intended was social housing. My lords, can I then please take you to 69. Secondly, reference is made there to the any other materials circumstance ground. In my view, the other material circumstance in this case, which was relevant to the application, include the failure of Millgate to take proper steps to test the public interest question at the appropriate time before breaching. But my lord, you have our submission on the fact that that is a misreading of the statute. Other material circumstances at the jurisdictional stage on a proper reading of the section don't include matters of conduct because of the narrow nature of the test of the question that's being asked. My lords, can I then go to over the page? Well, perhaps at the bottom of the page, 72, where the court is dealing with the question of the 1.64 million payment. The Upper Tribunal correctly noted the effect of the variation of Millgate's 106 was that Millgate could secure release from its obligations by the payment. But at 104, and in particular 106, in the Upper Tribunal's assessment in respect of section 841AB, it treated the provision of affordable housing as relevant to the public interest issue, but it left the possibility of provision of the same amount of affordable housing by the alternative means it had identified out of account. That was so even though those alternative means of provision would have meant that this aspect of the public interest could be satisfied without needing to override the restrictive covenant. Well, my lords, we say that it didn't leave it out of account as such. Paragraph 106 makes clear that the tribunal was mindful of it. It pointed out that the answer might have been different if that route was open to Millgate and it was applying before building. But that was not the factual situation that actually now faced the tribunal in making a decision. So it didn't leave it out of account, but it said that despite that, the public interest factor overrides any considerations regarding what might have been the position had the application been made before breach. And then in 74, it's right to observe at 106, the Appellate Tribunal has also emphasised that 13 units were immediately available. But by that point in its reasoning, it had already improperly discounted the relevance of the possibility of the provision of alternative housing, provision of affordable housing by the alternative means identified. It conducted no comparative analysis to ascertain when the alternative housing could have been made available. It would in fact very probably be housing already in existence. And we say that again, that wasn't left out of account. It didn't discount it. What the tribunal said was that it was no answer to the waste that would follow if modification didn't occur. And just a small point, we say that the evidence before the tribunal and indeed the Court of Appeal about whether or not the money would have been used probably for housing already in existence was extremely thin, to say the least. And if I get time, I will take you to the document that I say shows that. Turning to point B and the exercise of discretion, paragraph 120, it again attached critical weight to the public interest in providing affordable housing, but without bringing into account the possibility of such provision by alternative means. There was no proper basis for leaving this possibility out of account. But again, it didn't answer the point that there would be, I mean, it's the point in Ruton Park that despite the poor behaviour of the developer, the court in that case, as the tribunal in this case, were loath, despite that, to leave housing to be wasted. And that's the overriding factor. And then, my lord, 76, between G and H, as I understand it, at paragraph 118, the upper tribunal accepted Miss Windsor's submission for the trust that Millgate had acted in deliberate breach of the restrictive covenant in order to try and force the upper tribunal's hand to grant Millgate's application to modify the restrictive covenant in view of the waste involved in potentially having to take down the 13 units already built. Well, my lord, we say that doesn't follow from what the tribunal found. It didn't find that Millgate had acted in a way deliberately to try and the upper tribunal's hand. It's not the case that that was the finding of the upper tribunal, that the upper tribunal found only that the intention of Millgate in comparison to the good faith intention in the shown in the SJC case was at best unproven. And that's a different thing from saying that Millgate had acted in deliberate breach to try to force the upper tribunal's hand. And then I consider the upper tribunal fell into error. This is paragraph 77 in relation to discretion, assuming it arose. I think the arguments are more finely balanced. In my view, at the end of the paragraph, the upper tribunal still arrived at a conclusion which was wrong within the meaning of CPR 5221, and in that it failed to attach sufficient weight to the deliberately unlawful and opportunistic conduct of Millgate. And my lords, we say that, of course, that is not the right test. It's not whether it's wrong. The question is whether it's wrong in law. And we rely on the Edwards and Bairstow test in relation to disturbing findings of expert tribunals where a discretion is being exercised, namely the appropriate test being that the Court of Appeal in this case's decision had to be the only one and true conclusion that could have been reached. That's a very different thing from saying that the tribunal failed to attach sufficient weight to one of the factors.
Well, what do you say to the proposition that a different approach is that if an appellate court comes to the conclusion that the decision reached by the tribunal was one which no reasonable tribunal could have reached, that it's entitled to defer?
Yes, my lord, that's correct. The test in Edwards and Bairstow is put in several ways.
Yeah.
That is a paraphrase of one of the tests, but that of course is a high threshold to meet, and the authorities show that, which are included in the bundle. I won't take you to them. That
well, they're well known. Yeah.
that of course decisions of expert tribunals in particular merit respect, and the court shouldn't be too ready to interfere with decisions and find that as a matter of law, an error has been made. And the error, we say, is repeated again at 80, page 25, paragraph 80. I endorse what is said there. That's in the root of, this is the quoting from the observations by the tribunal at paragraph 115. I do not consider the upper tribunal identified any public interest factor of sufficient weight to outweigh these considerations, i.e. the considerations of the developer's behaviour and exercise its discretion. My lords, again, and finally, just at 84, where the Court of Appeal say the regime under section, this is page 27, regime under section 84 is carefully structured, and then towards the end, last 7 or 8 lines, I don't find the epithet egregious and unconscionable helpful. More accurate to say, in the present case, the application should have been refused in the exercise of discretion because Millgate had acted without proper regard to the rights of the trust and with a view to circumventing the proper consideration of the public interest under section 84. Under section 84. Lords, again, we repeat the point about the appropriate test, but in any event, that, in our submission, is an unfair characterization. There's nothing to support the idea that the breach was done for that purpose. My lords, I've spent perhaps over long taking you through the 2 decisions, but I felt it was important to put the Court of Appeal's decision in context. My lords, can I now address the grounds of appeal? Yes, my lord.
Yes,
sorry, just before you move off, back to paragraph 76, I just want to be clear what you're objecting to. The statement made by Lord Justice Sales was, as I understand it, the upper tribunal accepted the submissions that Millgate had acted in deliberate breach of the restrictive covenants. I stopped there. There's no objection, I assume, to that part.
No, my lord.
But you're saying, in order to try to put the tribunal's hand, etc., that is the part that you said there has been no findings to that effect.
My lord, yes, and I'm sorry if I rushed through it rather too quickly. What the tribunal found, in contrast to the SJC case, where it was accepted the applicant had acted in good faith and without an intention to force the hand of the beneficiary of the covenant, and what the tribunal say in 117, the same cannot be said in this case, as Millgate's state of knowledge and its intent are at best unproven. But that's a different thing to saying that it was done deliberately in order to try and force the hand of the tribunal. My lords, can I move swiftly to ground 1?
Yes.
Which is misconstruction of section 84, most of which I think I've covered. We say the natural wording shows the test is narrower. We say that there are no express procedural or process requirements for the jurisdiction to be engaged. And there is no definition of the public interest. Parliament has seen fit to leave it as wide as it is. Maloney Friends' written case seeks to rely on the principle of construction that where a property right, private property right, is being removed by a statute, that one interprets the relevant statutory provision in a way that favours the benefiting owner. We say that's not an appropriate analogy. The analogy made in the written case of the respondents is with compulsory purchase, which, and I hope to come to this in a little more detail, which is a different thing entirely. It's a public authority acquiring land in its own interest. That's totally different to a judicial tribunal with a set of detailed procedural rules, making a decision having admitted all possible objectors, all objectors who have the right to object and wish to, and hearing evidence and coming to a decision. It's quite different from a compulsory purchase power. In any event, of course, we say that there is no ambiguity in the word, so one doesn't even get to the stage where the principle that I've identified actually applies. My Lord, can I then just take you to well, make 2 points regarding the misconstruction that I say the Court of Appeal fell into error in relation to. In particular, in indicating that there were procedural aspects to the threshold being met. And that was an error for 2 broad reasons. It asked the wrong question at the jurisdictional stage, and it placed an inappropriate procedural gloss on the statute. The question posed by 84(1)AB is a simple one. Is the restriction in impeding the reasonable user contrary to the public interest? Questions of private actions and interests don't come into the matter at that stage. It's really solely about the use of the burdened land, and of course an impediment to a reasonable user, which is the test, will be just as much contrary to the public interest of if the applicant has first taken steps but failed, for example, to negotiate away the covenant, as if it has not. And the Court of Appeal's error was to ally the jurisdictional and discretionary stages of the test in relation to the public interest limb. It was the wrong approach to take. It contradicts, in our submission, the correct approach to the section identified in Shepherd and Turner, which is to not to seek to substitute for the statutory language, nor seek a degree of precision which Parliament has avoided. It's paragraph 23 of Lord Justice Carnwath's judgment in Shepherd and Turner at page 309 of the bundle tab 11, supplemental bundle tab 11, 309. It was no doubt thought appropriate to leave it to the tribunal as an expert body with the statutory function of promoting uniformity of decision to apply the section in a common sense way. My Lord, secondly, we say it ignores the sense of structure of the Act. So far as concerns the competing public and private interests, that is better dealt with at the discretionary stage rather than at the threshold stage, because there's an infinite variety of circumstances and factors which might bear on the question of the applicant's conduct, which is much better suited to being explored at the discretionary stage of the exercise. My Lord, thirdly, we say on the Court of Appeal's interpretation, it creates an imbalance because it means that in relation to the public interest limb alone, the discretionary stage is effectively rendered nugatory. The language of the section doesn't support that. If the question at the jurisdictional stage is whether upholding the covenant is in the public interest, but taking account of the public interest in upholding private contracts, it's difficult to see at the discretionary stage what the basis would be other than in favour of modifying. We also say that it introduces an unjustified incoherence into the scheme. Under section 84(1)(b), the upper tribunal is bound to take account of relevant conduct at the discretion stage as a material circumstance. But if the Court of Appeal is right, then in relation only to the public interest ground and not in relation to any of the other grounds, does one take account of conduct at the jurisdictional stage as well as at the discretionary stage. So, for example, if the application is brought under the limited benefit limb of AA, the conduct is plainly irrelevant to the question whether the covenant secures practical benefits of substantial value. And we say the best reading of the section is that it aims at a balance between the importance of private rights and the clear statutory aim of section 84 to allow those rights to be overridden in certain circumstances. The question of what, as a matter of discretion, those circumstances are is best dealt with as an exercise of discretion than the imposition of what has to be an uncertain test. And nor do we accept, my lords, the Court of Appeal's justification for the approach that it took. The Court of Appeal said that it was necessary in order to secure fuller protection and due respect for contractual rights sought to be overridden under section 84, and that it was wrong to leave it to the purely discretionary stage. One first questions why leaving it to the discretionary stage makes any difference in practice. It's just as much or little weight can be given to it in actually determining the outcome of the application. And in any event, of course, we say that that is not supported by the language of the statute, not only section 84(1)(a) and 1(b), but also, of course, section 84(9). And we make, my lords, very briefly, 4 main points in relation to the inappropriate statutory gloss. We rely again on the Shepherd and Turner point. We say it's an unwanted fetter on the unwarranted fetter on the upper tribunal's power and gives primacy to private contractual or equitable rights. And the fact that in this instance the developer might gain an advantage is incidental. It's contrary to the purpose of the statute, which is to permit, in circumstances that are strictly prescribed, private rights to be overridden. The third reason why we say that it's wrong is that it's impractical. My lords will know the difficulties of identifying beneficiaries with any ease, and often developers will take the view that they will let sleeping dogs lie as an appropriate approach, rather than trying to find and then explore the possibilities of negotiation with a number possibly of beneficiaries who may or may not have the benefit of the covenant. And of course, to suppose that negotiations can be carried out and then produced to the tribunal to show that proper steps have been taken is itself impractical. Negotiations are, of course, often conducted on a without prejudice basis. Indeed, a beneficiary who wishes to seek an injunction or wishes to put as much pressure on an applicant as possible or a developer as possible will insist on avoiding open correspondence because of the charge that money, that an injunction is inappropriate because the beneficiary was only interested in money. The respondents say, well, what's the problem with making an open offer? The developer simply making an open offer. And we say that there is. First of all, if he's thinking of taking out insurance or has insurance, it will often be a condition of the policy that the developer doesn't initiate contact with the beneficiary. And secondly, the conventional way in which this would be done would be by without prejudice correspondence. A developer may not want to concede or appear to be conceding the enforceability of the covenant itself, and making an open offer would be tantamount to doing so, even if the developer insists that he's reserving his rights. It's a recipe, my lords, for litigation and delay if negotiations have to be had first and exhausted before the application is made. My lords, it's convenient at this point for me just to deal briefly with a submission made by the respondents who draw an analogy with compulsory purchase powers in terms of the way the developers in our context, they say, ought to behave. And the point, I think, is made by reference to the Critchell-Down rules and to the procedural precondition to the making of a compulsory purchase order that negotiations have to be exhausted first. But, my lord, for the reasons I've already indicated, that is not an appropriate analogy. The powers of the upper tribunal are not powers of compulsory purchase. There is no acquiring authority. And my lords, for that reason, it's an inappropriate analogy to draw. Indeed, the test, of course, is different in compulsory purchase. The test is whether there is a compelling public interest in making the acquisition, and it's that itself that dictates the need to exhaust all other options before acquiring the property. But in the case of the public interest test in section 84(1)(ab), it's assumed that a reasonable user of land is being frustrated, contrary to the public interest, by the maintenance of the covenant. So, Lord, for those reasons, we say that the gloss is inappropriate. My Lord, the fourth reason we rely on is that it isn't supported by the authorities. And at this point, I do want to take the tribunal again briefly to the SJC construction case, the tribunal decision, which is in the other authorities bundle. That's tab 26 at 1397. My Lord, this again, as I indicated, was a case, as appears from the head note, where section 84(9) was used to stay the proceedings in order to allow an application to be made. And despite the breach of covenant, the application was allowed. But it's important to note that at page 1399, that the tribunal found that negotiations had been conducted with the council. This is just about halfway down the page. I may say in passing, page 1399, the council had concluded that having regard to the terms of the planning appeal, they could not properly without permission, properly withhold permission. Thereupon the applicants had discussions with officers. From those discussions came to the conclusion the covenant the council would agree to the necessary modifications of the restrictive covenant. Accordingly, they demolished Brambledown and commenced to build the block of flats. But the director concerned, and it's safe to assume all of the directors were fully aware that the council could not be bound by the officers, but they took what they knew, to be somewhat of a gamble. And my lord, the important passages appear at 1401 at the very bottom, where the tribunal, Douglas Frank QC, the tribunal, says at the very bottom of the page, I now have to consider paragraph B, the public interest limb, and he takes into account the following matters. That planning permission has been granted. Having viewed both sites in the area, I'm satisfied that it couldn't be, that the interference couldn't be described as serious, the scarcity of land. And then the fourth point is, if the restriction is not modified, then presumably the building work so far erected will have to be demolished, and thereby £47,000 worth of building will have to be wasted. That in the present economic circumstances is to be avoided. And then, my lords, in what we say is a parenthetical comment, I may here say that although the applicants were rash in proceeding with the development before securing a modification, I'm satisfied, as I think of the council, they acted in good faith in the sense they did not intend to force the council's hand. On the assumption that a substantial amount of compensation can be awarded, although there would be a loss, yet some other public interest could be furthered. Having regard to those considerations, the covenant was modified. And Lord, 2 points about that. The Court of Appeal rely on what I call the parenthetical statement to support the notion that in interpreting the threshold limb of Section 84(1)(b), one can take into account conduct. But my lords, I say that that's not an appropriate reading of that part of the decision. First of all, it's not one of the numbered points that appears to be relied upon. And secondly, it's not clear in this case whether the tribunal are there eliding the discretion and jurisdiction stage of the test, because when they come to modify the covenant, they don't consider discretion separately. There's a detailed discussion about the compensation, but at 1404, the tribunal say, having decided that it was appropriate to award compensation, that they're satisfied the restriction in impeding the user is contrary to the public interest. So, my lord, we say that doesn't support the reading that the Court of Appeal gave to the decision. And, my lords, if it does, it's again an example of an inappropriate statutory gloss. My lords, Re Collins, seeing the time, I'm not going to take you to the other authority. That's at, for your note, at Core Bundle, page 357. And the Fisher and Jimson case, which is in fact in the wrong tab. It's actually in tab 10. I think in the index it says it's tab 11, but that's at 1051. And the relevant passages are at 1054 and 1056. My lords, before I leave ground one, can I then just finally deal with the respondent's submission very briefly, that to allow the appeal effectively would be to allow, and indeed this was the effect of the tribunal's decision, was to allow a party to benefit from its own wrong. The point is made in my learned friend's written case that the tribunal at no point considered that its order put Millgate in a better position as a result of its deliberate wrong. Well, my lords, in relation to that, we say the following. First of all, the tribunal was indeed very conscious of that point and made the point that whether the circumstances would have been the same had the circumstances been different, had it not been a public interest case, then a different decision might have been reached. It's suggested that the court, by my learned friends, that the court ought to apply, in effect, imply a proviso that the right is not available, even if all the conditions exist, if those creating it did so as a result of wrongdoing. But also we fully recognise the principle that a party shouldn't be allowed to benefit from its own wrong, but we say there are three answers to the point. The first is that the principle relates to unqualified statutory provisions, where a party's deliberate wrongdoing brings it directly within the terms of that unqualified statutory provision. Secondly, we say that the authorities relied on by the respondents emphasise the need for a direct nexus between the statutory provision and the wrongful conduct, and that isn't the case where one is dealing with section 84(1), where of course ultimately the tribunal always has a discretion to refuse modification on the basis of the conduct. And thirdly, we say, aligned to that the point made overlooks public policy considerations. So in other words, the authorities my learned friend relies on are cases where private interests are concerned, but where there's a clear public interest in the jurisdiction being exercised, that will override considerations of wrongdoing, or may override considerations of wrongdoing, by a party that indirectly benefits from the exercise of the statutory jurisdiction. My lords, the relevant paragraph, without me taking you to the Welling-Hatfield case, which is I think the main authority my learned friend relies on, is paragraph 54 at pages 351 to 352 of the supplementary bundle. My lord, can I take you? The same point applies in relation to the Henley and Cohen case that my learned friend relies upon. That was clearly concerned with private interests, where there was an unqualified statutory provision which was engaged by virtue of the wrongdoing. And again, I refer to paragraphs 50 and paragraphs 59 to 61, which are in the supplementary bundle at pages 211 and 213. My lords, I also rely on a case which is in the supplemental bundle for your note, which is Boswell and Goodwin, which is the point, my third point, that Welling and Henley, the two cases my learned friends rely on, refer to a general rule. There are exceptions, and exceptions include where a public policy issue is involved. It's not a question under Section 84 of construing legislation to prevent a person benefiting from its own wrong. The question properly asked at the discretionary stage is one of judgment for the upper tribunal as to whether the wrong is sufficiently serious to outweigh the public benefit. And the upper tribunal made its answer clear on that point. My lords, can I move very swiftly to ground two? I am afraid I'm running very short of time.
Yes.
So we say the second error was of the Court of Appeal was to interfere with an evaluative judgment when overturning the public interest decision. My Lords, we refer to the AH Sudan case, which I shan't take you to, which is for your note at tab 3 of the core bundle, page 339, and to Shepherd and Turner, which is in the supplementary bundle in its reported form at 319. And we say that the Court of Appeal detected 5 errors of law, none of which were in fact error, wrongly postponing, indicating that the upper tribunal had wrongly postponed considerations of conduct to the discretionary stage, and that really relies very much on our interpretation of Section 84(1)(ab). The upper tribunal did not postpone considerations correctly to the discretionary stage. The second is that the upper tribunal was criticised by the Court of Appeal for following the guidance given by Lord Sumption. And we say that that guidance, if it is guidance, was not followed by the upper tribunal on a fair reading of the tribunal's decision. Again, my Lords, on the third point, where the Court of Appeal held at paragraph 68 that improper weight was given to the planning permission, we say this, that the upper tribunal was entitled to give primacy to the planning permission. It's clearly a material fact under Section 84(1)(b), as was the fact of Greenbelt designation. So it was a factor relevant to the consideration of whether the public interest limb was made out, that the planning authorities considered that there were special circumstances in this case, that the strong presumption against Greenbelt planning was overcome. So important, in other words, was the public interest in the provision of the 13 houses that it overrode the Greenbelt, 23 houses, in fact, under the permission, that it overrode the Greenbelt designation. But to give primacy to the planning permission is not inappropriate. My Lords, the fourth point, where we say the Court of Appeal wrongly interfered with the evaluative judgment, was in relation to the £1.64 million sum that was said to be wrongly left out of account. And for the reasons we've already stated, my Lords, we say the upper tribunal did take it into account in the paragraphs, particularly paragraph 106, which I've taken to you, we've spent some time on. And the criticism made of the tribunal doesn't answer the point that the tribunal was making, which was that it was dealing with the situation as presented to it now, and taking account of the pressing need for social housing. It made a balanced decision at the discretion stage that that was an irrelevant factor. It was equally an irrelevant factor at the evaluative stage for the reasons that we addressed this morning. Well, just a small point on this. In paragraph 74, the Court of Appeal said that no comparative analysis had been conducted as to the possibility of the housing becoming immediately available on the payment of the £1.64 million. But the real point is that even if it could have been made available immediately, on which evidence was lacking, it would still be wasteful for the 13 houses to remain empty. And in any event, we say it appears that there was no suggestion that housing could have been immediately available. And in that regard, we rely on the first sentence of paragraph 106 of the Tribunal's judgment at paragraph 176. My Lords, the fifth error, a very short point, but the Court of Appeal said that the Upper Tribunal was in error in not taking Millgate's conduct into account at the jurisdiction stage, and we say the Upper Tribunal was right not to do so. My Lords, my third ground of appeal, I see I'm already a minute over, my Lords. I don't know whether I'm going to be very short, but...
Right, well, take a few minutes, Mr. Hutchings.
My Lord,
Do take a few more minutes.
I'm grateful.
But no more, please.
No, my Lords, I note the time. My Lord, the third ground I can really make very briefly. We say that there was a wrong interference with the discretion, and I've already made my point about Edwards and Bairstow. We rely, and I shan't unfortunately be able to take you to particularly Obrey and the Secretary of State, which is in the bundle at tab 10, core bundle at tab 10, page 491, and it's paragraphs 13 to 18. And the Granada case, which is in the supplementary bundle at 128, paragraphs 156 to 158 at page 180. We say it was a matter for the Upper Tribunal's discretionary judgment, and it plainly fell within the specialist competence of the Upper Tribunal to make a decision in the way that it did. And plainly, it can't be said that no person acting judicially and properly instructed in the relevant law could have come to the determination that the Upper Tribunal did in accordance with the Edwards and Bairstow test. And the fact that the Court of Appeal lost sight of the Edwards and Bairstow test, even though, my Lords, I should say, I accept, contrary to what is said in my written case, I accept that the principle was drawn to the attention of the Court of Appeal in counsel's skeleton argument before the Court of Appeal, and I withdraw the suggestion that it wasn't put before the Court of Appeal. But the point I make is that the Court of Appeal lost sight of that, and that's apparent from the criticism, the express criticisms it makes about not placing sufficient weight, the tribunal not placing sufficient weight on a fact, and that's a classic matter which is outside the ambit of the jurisdiction to interfere with the tribunal's decision. My Lords, I was going to turn now and deal with one or two points in the respondent's case, but
Well, why don't you leave that to your reply?
My Lords, yes, that would be appropriate. I apologise for trespassing on your time.
Don't apologise, not at all. We'll sit again at 2:05. Thank you.